Good evening everyone. So the purpose of today's discussion is basically to go through the paper CL4, your law paper that was given in December 2021. So during this session I intend to discuss the answers for the questions that you were given in December 2021. Now all of you are aware that CL4 paper consists of three main sections. There are three main sections. In section 1, you get 10 MCQs where they have allocated 20 marks. On the other hand, in section 2, you get 4 questions where they have allocated 10 marks each, that is 40 altogether. And then in section C, you get 2 questions where they have allocated 20 marks each, again 40 marks in total. So during this discussion, I will be taking each and every section separately and will be discussing the answers for those questions. First, I am going to start with section 2 where you have 4 questions, and once you are done with that, I will be answering the questions in both section 1 and section 3. So that is the plan that we are having. With that, we can move to section 2. With that, we can look at the answers for those questions in detail. So as I mentioned, we will start with section 2. So there are 4 questions, and here you can see all questions are compulsory. Total marks for section 2 is 40 marks. And then recommended time for the section is 72 minutes. Now that is also extremely important because you have to answer your questions within the time period that you have been allocated. So that is something that you should keep in mind, because now you are going to have physical exams like we used to have in the past, and in an environment like that, you have to be very cautious when you are allocating your time. So as I mentioned, you have 3 sections in this paper, and you should take your time. To read the instructions given. So you have a reading and planning time of 15 minutes, and then you have 3 hours to write your answers. Now, one thing is very clear, there is no choice. You have to answer all the questions given. All questions are compulsory. Therefore, you don't have to basically spend your time to choose the questions that you are going to answer. So that you can avoid. However, you can decide whether you are going to start answering the questions from section A, section 1, section 2 or section 3. Now, my advice is, if you are going to answer questions from section 1, when you read the question, when you look at the question, straight away if you know the answer, go ahead and get it. Pick the answer, select the answer. But if you are not sure it, straight away don't waste your time, don't think twice, go to the next question. If you can't find the answer to the next question also, don't wait, go to the next question. So likewise, try to finish all the questions that you are comfortable with. Otherwise, you will be wasting your time to reread a question for which you are not sure about the answer. So if you are not sure about the answer for a question, don't waste too much time, go to the next question. So likewise, spend your time in a very productive manner to answer the questions that you are extremely comfortable with, because at the end of the day, you are sure, you are certain that you have scored something. Right? So keep that in mind. So allocating time is extremely important. And one other thing, this is an open book test. Therefore, you are permitted to take the Companies Act for the exam. You are permitted to take the Companies Act. Now here they have specifically mentioned the way that you can use the Companies Act. Be familiar with it. Be familiar with it. Before answering the questions from section 2, let me spend little time to go through that also. So, you must take a copy that you have obtained from the Publication Bureau. So, if you you can obtain a copy of the Companies Act from the Publication Bureau. So, that is the Companies Act that you should keep. So, examination will be conducted as an open book examination. Only the following publication will be permitted to be used at the examination hall, which is the Companies Act. I know for your exam there are some other acts relevant apart from the Companies Act. The main statute is the Companies Act, but there are some other acts as well, but you are not permitted to take those acts with you. There are some gazette notifications relevant to your paper, but you are not permitted to take any of those documents with you. The only piece of document that you can keep with you for the exam is the Companies Act. Then here it specifically states that notes, textbooks, other than permitted publications or any other materials will not be allowed, and photocopies or extracts of the above publication in the sense the photocopies of the Companies Act or the extracts of the Companies Act will not be allowed. So, that is why you need to obtain a copy from the Publication Bureau and keep that with you for the exam. Apart from that, you have a privilege, that is, candidates are allowed to bring or use the above permitted publications subject to the following. You can highlight the Companies Act, sidelining is possible, underlining relevant sections in the publications also allowed. Short notes in the permitted publication are allowed. So, when you are listening to a lecture, when you are studying, you can take down notes if it is something to do with, let us say, the duties of directors. So, if you want to write something about that particular duty, something in bullet point, or it can be, I mean, when you look at a section, I mean, these sections are very lengthy. Then what you can do is, you don't have to reproduce the whole section at the exam. Instead, what you can do is, you can explain the main points of the section. So, those things you can write near that particular section as a short note. Only if they are handwritten, but it has to be handwritten and are relevant to a particular paragraph or section in the publication, which explains that paragraph or section. So, it is very clear the way that you can do it. Any other notes written on the publication are not allowed. So, within those restrictions, you are permitted to deal with the Companies Act in a very favorable manner. So, make sure you get the maximum out of it, right. With that, now we will look at the questions that we have been given in section 2. So, there are 4 questions here, 10 marks each. Question 2, first we will read it and see. Amendra Das, who resides in India, intends to invest in a permitted capital investment in Sri Lanka. The Foreign Exchange Act number 12 of 2017, as I mentioned at the beginning, you can only keep the Companies Act. This is not a statute that you can keep with you at the exam. Therefore, you must be familiar with the main points under the Foreign Exchange Act number 12 of 2017. Specifies that such investment must be made through a certain type of account. Explain what this account is to AD. AD means Amendra Das. So, he is not a Sri Lankan resident. He is not a Sri Lankan, he is an Indian person, he is an Indian resident, Indian national. Now, he intends to invest in Sri Lanka. Permitted capital investment in Sri Lanka. There we know, as per the Foreign Exchange Act number 12 of 2017, you can normally invest in any type of industry in any type of business organization. However, there are some restrictions pertaining to that. There are some prohibited areas, there are some restricted areas. Subject to those conditions, you can invest in Sri Lanka as a foreigner. But if you want to bring your investment into Sri Lanka, it cannot be done in the way you want. As per the Foreign Exchange Act number 12 of 2017, if you want to channel your investment, if you want to bring your investment into Sri Lanka, there is a specific account that you have to open up. There is a specific account that you have to open up. Through that account only, you can bring your investment. So they are asking you to explain what this account is. I hope that you are very much familiar with this situation. Accordingly, you are aware that you have to channel your investment. You have to channel your investment through inward investment account. Through inward investment account. So you call it inward investment account. You have to channel your investment through IIA, inward investment account. So this particular Indian gentleman who intends to invest in Sri Lanka should bring his investment through the inward investment account. This inward investment account can be opened up in a licensed commercial bank or else licensed special bank. So this inward investment account can be opened in a licensed commercial bank or licensed special bank, licensed special or specialized bank. So identified or recognized by the Central Bank of Sri Lanka. Now, the importance of opening up this inward investment account is that if you don't bring your investment through this account, that's actually not directly relevant to the answer, but try to understand the practical application of it as well, then it's easier to remember. The purpose of opening up this inward investment account is, at some point, if you want to withdraw your investment from the country, you will not be permitted to take your money out if you have not opened up this inward investment account. So not only that, when you invest, you get a return out of it. It can be dividend, it can be a capital gain. When you sell your shares, you get sales proceeds, or else when you're holding your shares, you receive dividend, or else interest. So any return that you receive should also be credited to this account. And at some point, if you sell your shares, those proceeds should also be credited to the inward investment account. Then only that foreigner will be able to withdraw that money from the country. So that is the whole purpose of opening up this account. So there they have allocated 4 marks. So for that, you need to give the answer stating the main points that I stated in my explanation. So let's say oh, PDF, right. Okay. So in your answer, these are the main points that you should mention. So they have allocated 4 marks for this question. So the first thing that you should state, the name of the account, that is inward investment account, and then you can also mention that this is a special type of account designated for eligible investors resident in or outside of Sri Lanka. They can channel their funds through this inward investment account, and they are permitted to invest in permitted investments in Sri Lanka. So as I mentioned, as another point, you can state that this account can be opened up in a licensed commercial bank or licensed Specialized Bank in Sri Lanka. So these accounts are maintained in both licensed commercial bank and licensed specialized banks. They have something called DBUs, domestic banking units. In those DBUs, domestic banking units, you can open up this account. And you can also mention, since they have allocated 4 marks, include points to attract all 4 marks. So first you mention the type of the account, inward investment account, and then you explain that it's a special account that is designated for the eligible investors to bring their investments into Sri Lanka. And apart from that, also mention, don't forget to mention that whatever the returns, income that you generate from your investment and even your disposals of investment, the proceeds must be credited into this inward investment account, because through that account only you will be able to withdraw your money. So if you want further information, I can give you the study text reference. So if you go to page number 184 and 185 of the study text, you have the same explanation that I gave you. So basically this answer is based on pages 184 and 185 of your study text. All right. Then let's look at the next question. The shareholding of Vinyasa Private Limited, known as VPL, a company incorporated in Sri Lanka, is as follows. 60% is held by Amal, a Sri Lankan, and the balance 40% by Yoga, an Indian. VPL has purchased a land in Ragama, and the deed of transfer in this regard has been sent for registration to the Gampaha Land Registry. Under the Land Restriction on Alienation Act number 38 of 2014, the Registrar of Lands requires certain confirmation from the company secretary of VPL. The name of the company secretary is Anandi. Required, explain the confirmations that Anandi is required under the Act to submit to the Registrar of Lands in this regard. Now, this is a very common question that can be tested at the exam. It's a very common area, highly examinable area. You always get questions from this area. The relevant statute is Land Restriction on Alienation Act number 38 of 2014. So here you can see the act, but you are not permitted to take this act with you for the exam. So here, Land Restrictions on Alienation Act number 38 of 2014. Now in answering the question, there is a restriction when, if we go back to the question, you will see it's a company. It's a company. And what is the share structure of this company? 60% is owned by a Sri Lankan, 40% is owned by a foreigner. When a foreigner is trying to acquire a property in Sri Lanka, there are some restrictions. Actually, it's prohibited for them to acquire lands in Sri Lanka. However, they can go for a 99-year lease. I'll come to that later, but it's not relevant to this question. This is a company. A company is registered in Sri Lanka. Therefore, even for tax purposes, you are aware that the company incorporated in Sri Lanka should be treated as a Sri Lankan resident company. So, the company is Sri Lankan resident. But under the land restrictions and under the Land Restriction on Alienation Act, if the company's share structure, if there is a foreigner who has invested in the company, then that company's ability to acquire lands will be restricted. Accordingly, a company with a foreign shareholding can only acquire a property if the foreign shareholding is less than 50% in that company. Therefore, you have to always check if it is a company with a foreign shareholding, you have to check the percentage of the foreign shareholding. So, for a company to acquire a property, now according to this example, the company has purchased a property in Ragama. And now they have to register the deed of transfer in the Gampaha land registry. However, when registering the deed of transfer at the land registry, there are certain conditions to be met. A company cannot acquire a property in Sri Lanka if the foreign shareholding of the company is more than 50%. Accordingly, for a company with a foreign shareholding, to acquire properties in Sri Lanka, the foreign shareholding should be less than 50%. Foreign shareholding should be less than 50%. Now, those conditions are met here according to the scenario that you have been given. 60% of the shareholding is owned by a Sri Lankan person. Only the balance 40% is owned by the foreigner. So, it is less than 50%. Of course, this company can purchase this property. There are no restrictions because of that under the Act. But the secretary of the company has an obligation. After submitting the deed of transfer for registration, which they are permitted to do as the requirements are satisfied, that is, the foreign shareholding is less than 50%, but from the date of registration, every 6 months, the company secretary has an obligation to inform the registrar of the land registry with regard to the shareholding of the company. Because otherwise what can happen, at the time of registration, they can maintain a lower shareholding, a shareholding less than 50%, because otherwise you can't register the land. Then after registering the land, they can increase the foreign shareholding in violation of the Act. That is why the company secretary has an obligation to inform the registrar of the land registry that the shareholding of the company has not changed. It's still, the foreign shareholding is less than 50%. So, that is the requirement under the Land Restrictions on Alienation Act number 38 of 2014. So, if you look at the Act, section 3, section 2 actually, here restriction on transfer of land, notwithstanding any provisions in the contrary in any other written law, the transfer of title of any land situated in Sri Lanka shall be prohibited. If such transfer is to a foreigner or to a company incorporated in Sri Lanka, this is the important part, under the Companies Act, where any foreign shareholding in such company, either direct or indirect, is 50% or above. So, the foreign shareholding has to be less than 50% for that company to acquire the property in Sri Lanka. So, answering the question that you have been given here, these are the important points that you have to mention in your answer. In relation to this deed of transfer, the Act requires the company secretary, Anandi, to submit the following confirmations. They are asking what are the confirmations that this company secretary has to submit to the Registrar of Lands. First confirmation that she has to submit is the foreign shareholding of the company, that is Vinyasa Private Limited, VPL, is less than 50% at the time of at the time of submitting the deed of transfer. At the time of submitting the deed of transfer, the foreign shareholding is less than 50%. And apart from that, you have to also mention once the deed of transfer is registered at the land registry, every 6 months from the date of registration, the company secretary has an obligation to give a confirmation that the shareholding of VPL of this particular company has not exceeded 50%, 50% or more. It shouldn't be 50% or more. So, every 6 months you have to give this update to the registrar of land. So, those are the confirmations that the company secretary in Vinyasa Private Limited has to give. So, one hand, at the time of registration, the shareholding of the company should be less than 50%. That confirmation must be given. And after registering the deed of transfer, every 6 months you have to notify the registrar of lands that the foreign shareholding has not exceeded 50% or more, has not exceeded 50%. So, it should be less than 50%. So, that is how you should answer the question. And for further information, you can refer to page 189 of the study text. If you refer to page number 189 of the study text, you will be able to get a better understanding if you require further information. So, that is how you should answer that particular question. So, when you are doing this, you also can get an idea the type of areas that can be tested at the exam. So, you can see the question that we just completed, question number 2. Part A is a question that has been given from the Foreign Exchange Act number 12 of 2017. You always get questions from this area, so something that you cannot avoid. And the other thing is you are not permitted to take this statute with you for the exam. The second part of the question is also from a different statute, not from the Companies Act, that is Land Restriction on Alienation Act number 38 of 2014. So, you must be familiar with these statutes as well, and these are commonly tested areas. So, you can prepare yourself now itself for the exam by going through the relevant statutes that I mentioned, and I gave you the relevant parts in the textbook as well. The study text reference was also given. Then question number 3. The directors of Udayakanti Enterprise Private Limited UEPL are looking at the option of listing UEPL in the Colombo Stock Exchange and have consulted you in this regard. First question, summarize the benefits of such a listing. Right. Now, this is with regard to the listing of a company in the Colombo Stock Exchange, and you are aware, for you to list a company in the Colombo Stock Exchange, it has to be a company which is not a private limited company. So, if you want to list the company in the Colombo Stock Exchange, then you cannot function as a private limited company anymore. Now, according to this question, it is a private limited company. Once it is listed in the Colombo Stock Exchange, it permits the general public to invest in this company. As a result of that, it will no longer be treated as a private limited company. It will be treated as a public limited company, PLC, public limited company. So, here you have to, it is a theory question, summarize the benefits of such a listing. Currently, what it is? It is a private limited company. So, when you remain as a private limited company, you are aware that there are some restrictions. Because as a private limited company, it is prohibited for you to issue shares, debentures and other securities, mainly shares and debentures, to the general public. It is prohibited. You can't publicly invite outsiders to invest in your company. You can't advertise, you can't market if you are a private limited company. So, you have to issue shares and debentures to known parties. Privately, you can issue shares and debentures. Now, because of that, so you can issue your shares and debentures to your friends, to your family members, only to known parties. You can't advertise, you can't publicly invite outsiders to invest in your company. As a result of that, your ability to expand the business will be restricted, and your ability to raise more funds will be restricted. And the other thing is, think practically. There are so many private limited companies in Sri Lanka, but most of us are not familiar with the names of such private limited companies. But if you refer to a public limited company, a company which is listed in the Colombo Stock Exchange, most of us are aware of such companies. Let's say a bank, Commercial Bank PLC, Sampath Bank PLC, John Keel's Holdings, Hemas. Likewise, the moment you mention the name, you know the name of the company, you know the company. That is because those companies are listed in the Colombo Stock Exchange. So once a company is listed, basically it will improve your image in the market. People will get to know about the company. The reputation of the company will increase. As a result of that, you will be able to attract more customers. You will be able to attract more investors because you will be able to boost the confidence in the general public. If you want to issue shares, the investors will be reluctant to, even though that person is a friend of yours, even though a family member, they will be little reluctant to invest in your company if you are not known to them. But if you are a company listed in the Colombo Stock Exchange, that will increase the confidence in that particular investor. Because you can't easily list a company in the Colombo Stock Exchange. There are some strict rules and regulations to be followed. There are certain requirements to be satisfied. Therefore, when you invest in a public limited company, the investor knows that there is some kind of a security for their investment. They know that there is a security for their investment. And the other thing is, whenever they want, they can leave the company by selling their shares, selling their debentures. But if you are in a private limited company, most of the time what happens is, basically you are locked. You are locked. Unless you find a potential buyer, you will not be able to sell the shares to an outside. So therefore, that kind of restrictions are there when you continue as a private limited company. Hence, there are so many benefits, as I explained, that is attributable to a company listed in the Colombo Stock Exchange. So if I may point out whatever the benefits that I mentioned here, you can write them down. And if you want further information, you can refer to pages 157 and 158 of your textbook. So refer to those pages, then you will be able to find the benefits of listing this particular company in the Colombo Stock Exchange. So if I may give you some of these benefits, one is listed securities are preferred by investors as they have better liquidity. Because as I told you, if you invest in a private limited company, whenever you want, you can't leave the company by selling your shares or debentures. There is no readily available market for you to dispose your shares. But if you invest in a listed company, there is a readily available market for you to dispose your shares. That means the liquidity of such securities are greater than a private limited company. So that's a benefit from the investor's point of view. Then on the other hand, listing provides wide publicity to the companies since their names are mentioned in the stock market, reports, analysis in newspapers, magazines, TV news channels. So that's why I told you it will enhance the image or the appearance of the company, because once a company is listed, the company's name will appear on the stock exchange reports. Then in newspapers, magazines, TV news channel, because some of these information, these companies have an obligation to publish. The financial statements must be published, unlike a private limited company. Then another point, the listing provides a company better visibility and improves its image and the reputation, something that I mentioned. Then it makes future financing easier and cheaper in case of expansion or diversification of the business. As a private limited company, your ability to expand or diversify will be extremely remote. But as a listed company, you have a very good potential to expand the business, because you have the ability to raise funds by issuing debentures and shares to the general public. And also, the company will experience growth and stability in the market through broadening and diversification of its shareholding. Then listing attracts the interest of institutional investors of the country as well as foreign institutional investors. What do you mean by that? Who are institutional investors? Institutional investors are basically another business entity, such as insurance companies, banks. Now, insurance companies, what they do is they collect funds from different people and they go and invest. Banks, what they do? They also collect money by way of deposits and they go and invest in other investment opportunities. So, they seek investment opportunities. They go and invest whatever the funds collected in other companies. They maintain a portfolio. One option is to invest in a company. Now, these banks, insurance companies and other and investment banks especially, these institutions, what they do is they collect funds, even unit trusts. They collect funds from people and they go and invest. But when they are investing, they will be very reluctant to invest in a private limited company because the risk is extremely high. Therefore, they will not take that risk. They will not invest in private limited companies. One thing, you can't withdraw your investment whenever you want. The liquidity is very low. But they prefer to invest in listed companies. They prefer to invest in listed companies. That is because they can withdraw their money at any time they want, and on the other hand, the credibility is there. Because banks, insurance companies, they are dealing with funds collected from the general public. Therefore, they can't deal with their funds in the way they want. Therefore, they will always be cautious when they are investing the monies that they have collected. So, most of the time what they do is they will invest in listed companies, not in private limited companies. Even foreigners, when they want to invest, they will not want to invest in a private limited company not known to anyone. But if they want to find information, they can easily find information with regard to listed companies. If you can do a Google search to find enough information about a listed company than a private limited company. So, the foreigners can get more information, their financial statements, the recent reports from the Colombo Stock Exchange, and go through it before investing in the company. And you guys are aware, for financial management, you would have learnt it. If you want to value a business, it will be easier for you to value a business if it is a listed company, because you have all the information required to value a business. But if you take a private limited company, it will be extremely difficult to value a business. And on the other hand, let's assume I am an investor invested in a listed company. When I am holding a share, I can easily find out the value of my share, because the share price fluctuates based on the demand and supply, but it is available for you to check daily on the Colombo Stock Exchange. You can check what is my share value. I have 1000 shares at Commercial Bank PLC. Can't I find out the value of those shares today? I just have to visit the Colombo Stock Exchange website. From that, I can find out the value of a share. Today's value I think it was 51 rupees. So if I have 1000 shares, my share value is 51,000. But if I have invested in a private limited company, do I have that privilege? No. I don't know what the value of my investment. Therefore, there's some kind of an uncertainty when you invest in a private limited company. So apart from what I mentioned, then you also can state these points also. Listing enables a company to know its market value, that is what I mentioned, and this information is useful in the case of mergers and acquisitions to arrive at the purchase consideration, exchange ratios, etc. That's I told you in financial management, when you do amalgamations, when you do takeovers, you should know what is the value of the business valuations. It's very difficult to value a business if it is a private limited company, but if it is a listed company, it's very easy. And then I mentioned this also, by complying with the listing requirements, the operations of the company become more transparent and investor friendly. It further enhances the reputation of the company, because any company cannot be listed. There are very strict rules and regulations to be followed. When you follow those rules and regulations, automatically the company becomes a transparent company. You have a nice system in place, unlike a private limited company. All the documents are there, so you can easily obtain the relevant information. So those are the main points that you can mention in your answer to secure 6 points for this question. And also as a final point, you can mention the listing improves supplier, investor and customer confidence and improves your standing in the marketplace. So as I mentioned previously, please refer to pages 157 and 158 of your textbook for further information. So that is part A of question number 3. Then B, a recent newspaper carried an article calling for interested parties to submit application to invest in certain prime lands in Sri Lanka. Keith Harris, a Denmark national who saw the article, is interested in investing in some lands in his personal capacity. As a result, he has submitted 2 applications, one to purchase a land in Colombo to another to obtain a land in Nuwara on a 100-year lease period. 100-year lease period. Okay. Now, you have to be very cautious. As I mentioned previously, they have given you another question from the same area we looked at previously under the Land Restrictions on Alienation Act number 38 of 2014. So this is also a question given from the same statute. Now, according to this question, a Denmark national, a foreigner, intends to invest in 2 properties in Sri Lanka. One is to purchase, buy a property in Colombo. The other one is to acquire a lease in Nuwara for a period of 100 years. So what is the requirement? Explain whether Kate's application can be accepted or not under the Land Restrictions on Alienation Act number 38 of 2014. So you can pause the video before listening to my explanation and see whether you can find the answer, and then listen to my explanation. That will be more productive. I have already given the answer. I told you foreigners, foreign nationals are not permitted to purchase properties in Sri Lanka. They can't purchase properties in Sri Lanka. So his intention to acquire a land in Colombo will not be permitted. It will not be accepted. And then he wants to enter into a lease agreement for a land in Nuwara for a period of 100 years. What is the answer? I have actually given the answer earlier. A foreign national can enter into a lease agreement, but the maximum time period is limited to 99 years. Therefore, he cannot put forward an application to acquire a land in Nuwara on a 100-year lease period. It's not possible. The maximum time period for a lease agreement is restricted to 99 years. Colombo land he can't purchase, it's prohibited. Lease, since it's for 100 years, again not permitted because the maximum time period is 99 years. So that's what you have to mention in your answer. So if you look at section 2 of the Land Restrictions on Alienation Act, it's very clear, notwithstanding any provisions to the contrary in any other written law, the transfer of title of any land situated in Sri Lanka shall be prohibited if such transfer is to a foreigner. So here the person mentioned in the question is a Denmark national, a foreigner, therefore he cannot acquire the property. Unless exempted as provided in section 3, but he does not come under any of these exemptions, then about the lease you should go to section 5. Here, notwithstanding any provisions to the contrary in any other written law, the leasing of a land to a foreigner or to a company. So here leasing of a land to a foreigner shall be effected subject to the payment of the land lease tax imposed under section. This is the requirement, this is the restriction, provided however the maximum tenure of any such lease shall not exceed 99 years. So as per section 2 of the Act, KH is not entitled to purchase the land in Colombo. As per section 5, it doesn't matter whether you mention the section or not, but I am giving you a complete answer. As per section 5 of the Land Restriction on Alienation Act number 38 of 2014, it's not possible for him to enter into a lease agreement for a period of 100 years because it's restricted to 99 years. So that is how you should answer that question. Straightforward one, but you should be familiar with the relevant provisions of the Act. Then only you will be able to give the answer. But as I told you, if you look at the other past papers as well, if you look at the other past papers, you will be able to see this is an area that has been tested quite frequently. Therefore, it is an area that all of you must focus on when you are preparing yourself for the exam, right? Then let's look at question number 4. Let's look at question number 4. Jayalat Karunaratna JK is a director of Chimes Company Private Limited, hereafter known as CC, Chimes Company. Terence Ranasinghe TR, a shareholder of CC, has received reliable information that JK is about to contravene a provision of the Articles of Association of CC. In instances like this, the Companies Act number 7 of 2007 has introduced a new relief termed as restraining orders. TR is considering, that is the shareholder of this company, considering utilizing this option. Explain what this relief is and whether TR can utilize it. Now, since it's a scenario based question, you have to give your answers precisely. You don't have to explain the history or the evolution of these restraining orders, because if I may give you an explanation, the restraining orders were not there under the old Companies Act 1982. It was introduced as a very good remedy under the new Companies Act. So, it is a remedy that was introduced to the shareholders of the company under the new Companies Act. Now, restraining orders can be obtained if the company or the directors of the company make an attempt to enter into a transaction in violation of the Companies Act or in violation of the Articles of Association. You are very well aware, all these things are not important to the answer, but I am just explaining, I am just giving you a background for you to get a better understanding, that is the whole purpose. Directors are responsible for the management of the company. The directors are subject to certain duties, statutory duties specified in the Companies Act. One of such duties is that the directors have a duty to act within the powers. They have to act in good faith in the best interest of the company. In doing that, they have to act within the powers given to them. Directors have been given the power to manage the company without a doubt, but their power is restricted. How it is restricted? Through the provisions in the Companies Act and through the Articles of Association. So, the directors have the power to make decisions with regard to the management of the company, but it is subject to the restrictions provided under the Companies Act and also in the Articles of Association. So, if the Articles of the company, which is the constitution of the company, if it imposes a particular restriction on the director's ability to make certain decisions, obviously the director should comply with it. Now, here what has happened, we do not have to explain all those things, but here what has happened, Jayalat Karunaratna, JK, who is a director of the company, is now trying to do something in violation of the Articles of Association, Articles of the company, in violation of the constitution of the company. So, a shareholder, Taran Ranasinghe, who is a shareholder, has received a reliable information that a director is about to contravene a provision of the articles, about to contravene. He has not done it yet, he is going to violate the articles. So, under the Companies Act, you can obtain a restraining order to prevent this particular director by entering into a transaction or by doing something in violation of the articles of the company. Now, let us look at the Companies Act. Let us look at the Companies Act. Section 233, Section 233 refers to restraining orders. The significant feature of this kind of an order is that you can obtain this order if the transaction has not yet occurred. It is an injunctive relief. If you obtain a restraining order, it is similar to a final order that you have obtained from a court, similar to a final judgment issued by a court. Here, through this order, you prevent the director by entering into this particular transaction in violation of the articles. But what if the director has already entered into the transaction? Then is there any point of obtaining a restraining order? Then there is no point of obtaining a restraining order, because the whole purpose of this order is injunctive in nature, is injunctive. is to prevent someone by doing something. If he has already done it, there's nothing to prevent. There's no reason for you to obtain a restraining order if the event has already taken place. That's why the question very clearly says the shareholder has received a reliable information that the director is about to, that means he has not done it yet, about to contravene a provision of the articles. Then of course, you have the freedom as a shareholder to obtain the restraining order as per section 233. So what does it say? The court may, on an application made under this section, make an order restraining a company that or a director of a company. Here you want to obtain the order to restrain the director who proposes to engage in a conduct that would contravene the articles of the company or any provision of this act from engaging in that conduct. So who can make an application under section 233? Either the company, a director or shareholder of the company. So here a shareholder wants to obtain a restraining order. Yes, he is permitted to obtain a restraining order under section 233 subsection 2. Accordingly, he can make an application to court to obtain a restraining order to prevent the director by engaging in this activity which will be in violation of the articles of the company, the constitution of the company. So this acts as a final order. So anyway, in your answer, these are the important aspects that you have to mention. One is what this relief is. It is obtaining a restraining order which is an injunctive relief. That is in the nature of a injunctive, to prevent someone by doing something, but it comes as a final order, final relief. This can be granted by court. As per section 233, as per section 233 of the Companies Act, either the company, a director or a shareholder. In this instance, the shareholder wants to bring an application to obtain a restraining order. Therefore, it is very clear TR as a shareholder is permitted to bring this action under section 233. Accordingly, you can extract the relevant parts from section 233 and you can reproduce that in your answer. So, the court may 233, this part you can include in your answer. The court may, on an application made under this section, make an order restraining a company that or a director of a company who proposes to engage in a conduct that would contravene the articles of the company or any provision of this act from engaging in that conduct. In this instance, there will be a contravention of the article, so obviously it is permitted to obtain a restraining order in such situation. So, this is as I mentioned at the beginning, it is an injunctive relief in the nature of a final order. So, it has an effect of a judgment issued by a court. So, those are the important things that you should mention in your answer. Further, you can refer to section page 129 of your textbook. For further information, please refer to page number 129 of the textbook. Okay. Then the next question. Arunasiri Pereira recently purchased 5% of shares of ABC Private Limited. ABC Private Limited. Subsequently, he got to know that his name has not been updated in the share register of ABC. In the share register of ABC. Upon inquiry, AP was told that the company has instructed the company secretary not to include AP's name in the share register. So, you have bought some shares in this particular company and has become a shareholder, but you have found that your name does not appear in the share register. Every company has to maintain a share register. There are several registers to be maintained. Share register, the directors register, the secretaries register, the interest register, charges register, register for the charges. So, likewise there are certain registers that must be maintained. One such register that has to be maintained by a company is the share register. So, here he has got to know that the share register has not been updated and his name does not appear in the share register as a shareholder. So, that can cause an issue on him at some point if he tries to sell his shares, if his name does not appear. And at the time of liquidation also, he will find it difficult to recover his money for the shares that he has bought if his name does not appear in the share register. Therefore, he has to make an application to include his name in the share register. Here what has happened, when he made an inquiry, he has been told that the company has instructed the company secretary not to include his name in the share register. Then what is the remedy available to this particular shareholder? How can he include his name in the share register? So, advise AP as to the action he can take under the Companies Act number 7 of 2007 to get his name included in the share register of ABC. So, this is also a question directly from the Companies Act. Now, the relevant section is section 128. So, that is why 128. So, you should be familiar with the relevant provision. So, this is the table of content where you get all the sections. So, section 128 refers to rectify a share register. For this also you have to make an application to court. The court has the power to rectify a register on an application made by a shareholder of the company. So, let us look at the relevant provisions. Right. Where the name of any person is without sufficient cause entered in or omitted from the share register of a company, that is what has happened. His name, without sufficient reason, his name has not been entered, or default is made, or unnecessary delay takes place in entering on the register the fact of any person having ceased to be a shareholder. This is when you want to become a shareholder. This is when you cease to be a shareholder. Any person aggrieved or the company or any shareholder of the company may make an application to the court for rectification of the register. Accordingly, this particular shareholder can make an application under section 128 to court to rectify the register and include his name as a shareholder of the company. Where an application is made under this section, the court may order rectification of the register and payment by the company of any damages sustained by any party aggrieved in a situation like that. And you can see, when the court makes an order to rectify the share register by including a name, and if the company fails to comply with this requirement, the company shall be guilty of an offence and be liable on conviction to a fine not exceeding 100,000 rupees. So what you have to do is basically you have to be familiar with the provisions in the Companies Act. You don't have to be familiar with all the provisions in the Companies Act. Whatever the provisions applicable to you can be found in the textbook. From the textbook you can identify the areas that will be tested. So there you can identify the scope of your syllabus. What are the sections, what are the areas that will be tested. So everything, now whenever I am explaining the answer, I refer to the relevant page number of the textbook. So it's from the textbook, the answers are from the textbook. Since you can't take the textbook with you for the exam, the alternative that you have is you can use the Companies Act instead. But you should be able to create a connection between the Companies Act and the textbook. The textbook, from the textbook you extract the relevant provisions. Understand these are the provisions that will be tested at the exam. So highlight them, underline them, identify the areas that can be tested and go through the Companies Act, especially the table of content again and again. And that is how I mentioned section 128. Straight away when you refer to section 128, the answer is there. So you can extract the relevant parts from section 128 and include in your answer. You can reproduce most of these parts from the Companies Act, and if you include those things in your answer, you can easily score good marks at the exam. So in this situation, you can refer to section 128, subsection 1. What does it say? It says, where the name of any person is without sufficient cause omitted, entered in or omitted from the share register of a company, then the person aggrieved. This is not relevant to the given scenario, only part A, 1A is relevant. So you can reproduce this part with the balance part. So where the name of any person is without sufficient cause, entered in or omitted from the share register of a company, the person aggrieved. Here the shareholder is the one who is aggrieved, or the company or any shareholder of the company. So in this instance, the shareholder who is aggrieved by that can make an application to the court for rectification of the register. So obviously he has a remedy. So as per this section, AP who is aggrieved by the conduct of the company, where they have informed the secretary to not to include his name in the share register, he is obviously aggrieved by that and he has the right to make an application to court for the rectification of the share register. And further, if you look at section 128 subsection 3, it says, on an application made under this section, the court may decide any question relating to the title of any person. You can reproduce this part also, who is a party to the application to have his name entered in or omitted from the register, where the question arises between shareholder or alleged shareholders or between shareholders. So this part is not actually, the latter part is not important. What matters is, on an application made under this section, the court may decide any question relating to the title of any person who is a party to the application to have his name entered in or omitted from the register. Or any other question necessary or expedient to be decided for rectification of the register. After considering all those things, the court can make an order to rectify the register and include his name as a shareholder. If the company fails to do that, the officers of the company will be in violation of the Companies Act as per section 128 subsection 5. So those are the main parts that you have to mention in your answer to secure 5 marks for this question. Right. Then that's question number 4. So, we are done with question number 4 now. Let's look at question number 5. So, basically the last question under section 2. Let's say right. Albert Gunaratne wants to promote a company to export cashew products from Sri Lanka to Middle Eastern countries. In this context, he purchased in his name a land with a cashew plantation from Puttalam and immediately sold it to the company at a profit. The company and its shareholders got to know about this series of transactions through a third party. Explain to AG, that is Albert Gunaratne, what is his duty was as a promoter in relation to the above scenario. Okay. Now, who is a promoter? Who is a promoter of a company? Who is a promoter of a company? Who is a promoter of a company? A promoter is a person who takes the initiative to start a company. He's a person who will get involved in the incorporation of the company. He will do the necessary arrangements with the suppliers, the potential customers, potential suppliers to commence the business activities on behalf of the company. He may even enter into transactions, contracts prior to its incorporation on behalf of the company. We call them pre-incorporation contracts also. So, that is the role of a promoter. However, a promoter has a fiduciary duty. It's like a fiduciary duty means a duty to act in utmost good faith. If you think of a relationship, if you think of the relationship between a doctor and a patient, an auditor and his client, a lawyer and his client, there you would see they have a fiduciary duty because one party is in a position to exploit the other party. Therefore, you have to always act in good faith. In doing that, as a promoter, when acting in good faith, there is a very important principle that you need to maintain. That is, a promoter must avoid any secret profits. The promoter must avoid any secret profits. Secret profits. Secret profits. A promoter is not entitled to generate any secret profit using his position as a promoter. Now, in this particular question, what has happened? AG, that is the name of the promoter, that is the name of the promoter. What he has done, he has purchased a land, he has purchased a land in his name, in his name. He has purchased a land in his name. Let's say for 5 million. He has purchased this land in his name for 5 million. Then what has happened? He has immediately sold this land to the company. Now, he is in the process of forming a company. So, he has first purchased the land in his name and immediately sold the land to the company at a profit. At a profit. Let's say he has sold it to the company for 7 million. So he has generated a profit of 2 million from this transaction. But he has never disclosed this to the company or its shareholders. Now what has happened? Now what has happened? The shareholders of the company got to know about this series of transactions from a third party. The shareholders have got to know about this transaction from a third party. Explain to AG what is his duty was as a promoter in relation to the above scenario. So this is the scenario. He has generated a profit of 2 million according to my example, 2 million or whatever profit he has generated. It has never been disclosed to the company and its shareholders. Since it has not been disclosed, it remains as a secret profit. Promoters can earn a profit, but it must be disclosed to the company and its shareholders. So here he is in breach of his duty as a promoter because he is not permitted to generate any secret profit. Whatever the transaction, if he has got involved in any transaction, it must be disclosed to the company and its shareholders. Since he has failed to do that, whatever the secret profit that he has generated, he has to return it to the company. Because this secret profit, because he cannot generate a secret profit, that profit must be kept as an implied trust on behalf of the company. It doesn't be, I mean, he cannot utilize this, it doesn't belong to him because it's a secret profit. So you have to return this to the company. So that is the, because promoter has a fiduciary duty and now he is in breach of that fiduciary duty. He has generated a profit which has not been disclosed to the company and its shareholders. So he is in breach of that duty as a promoter. What is the duty? Not to generate any secret profits. Not to generate any secret profit. If it has been disclosed to the company, then there won't be any breach because it's not going to be secret then. Here the issue is it has never been disclosed to the company. So in that line you have to answer the question accordingly. See whether you, before listening to my explanation, as I mentioned previously, pause the video, read the question, go through the textbook, go through the Companies Act and write your own answer. And then listen to this recording. Then listen to this video and see my explanation and compare your answer with the explanation given here. So see whether these parts are included in your answer. See whether these parts are included in your answer. So here AG has acted as the promoter of the company in this scenario. As a promoter, he has a duty not to make any secret profits out of the promotion of the company. It doesn't say you can't generate profits, it says you cannot earn, you cannot make any secret profit out of the promotion of the company, not possible. Here, a secret profit is made by entering into a transaction on the promoter's own behalf. Because he did not buy the property straight away in the name of the company. Instead, first he bought it in his name and then sold it immediately at a profit to the company. So you have misused your position as a promoter to gain an undue advantage. A promoter is not permitted to do that. So this profit has been generated, he has earned this profit without making disclosure of the profit to the company or to its shareholders. Therefore, AG in this instance as the promoter has a duty to make a full disclosure to the company of all the relevant facts, including the profit made by him as the promoter in the transaction with the company. So he has to explain it. So he has to say that he purchased it for this particular price in his name and then he has sold it to the company at this price and generated a profit. A full disclosure without hiding any important information. Since AG has failed to do this full disclosure, the profit made by him in this particular transaction, he will be liable to give it back to the company. So, he has to make good the loss suffered by the company. He has to make good the loss suffered by the company. According to my explanation, that profit 2 million, he has to give it back to the company since he has failed to make a full disclosure. Right. So, that is the answer for part A of this question. Then, currently XYZ Private Limited is a going concern. The directors of XYZ have decided to wind it up through courts as they foresee going concern issues in 2020 resulting from the macroeconomic environment of the country. As a result, Salim has been specially appointed by court to conduct the winding up proceedings of XYZ for the furtherance of this purpose. Salim is legally empowered to act on behalf of the company in various capacities. So, when you are reading the question, straight away you should be able to understand the position held by Salim in this situation, the role that he has to play in this situation. Required, state the position to which S has been appointed by court in this instance. What is the position that he is holding in the company? He is holding the position of a liquidator, and 4 of the powers and duties conferred on S, conferred on a liquidator by the Companies Act number 7 of 2007. So, again, once you identify that they are referring to the position of a liquidator, then if you know the relevant sections, from there you can gather the powers attributable to a liquidator and you can easily score 6 marks in this situation. By the way, for the previous one, for the previous question, if you require further information, you can refer to page number 31 of your textbook, that is with regard to promoters. And then part B about liquidators, you can refer to pages 111, 113 and 114. 111, 113 and 114. So, first you have to mention the position to which S has been appointed. So, based on the information given in this scenario, it appears that Salim has been appointed by court as the liquidator. Then you can explain the powers and duties of a liquidator. You have to state only 4. For that we can refer to the relevant section. I think it's section 292 of the Companies Act. Let's see. Yeah. So, you can see from the table of content, if you are familiar with it, straight away you can figure it out. Section 292 explains the powers of liquidator. What are the powers? What are the powers? The liquidator in winding up by the court. So, when a liquidator has been appointed by court, then such liquidator shall have power with sanction either of the court or of the committee of inspection. Committee of inspection means sometimes a liquidation committee can be appointed to oversee the work of a liquidator, but that is not relevant to the answer. So, I am not going to touch that area. However, these are the powers granted to a liquidator appointed by court. So, one power is to bring or defend any action or other legal proceedings in the name and on behalf of the company. To carry on the business of the company so far as may be necessary for the beneficial winding up of the company. I believe that you understand the meaning of the first one. Even though you do not understand, actually it does not matter. You have to reproduce the answer. You can reproduce these powers and include in your answer. So, you can secure full marks for this question. But the important skill that you need to develop is how to identify the relevant section. Once you identify the relevant section, you just have to extract the relevant parts from the section and include in your answer, right? So anyway, to bring or defend any action or other legal proceedings in the name and on behalf of the company, because now the company is struggling, the court has appointed a liquidator. So when the liquidator's main obligation is to sell all the assets and settle the liabilities. In doing that, some creditors may take legal action against the company saying that their liabilities are not included in the financial statements of the company. So parties can take legal action. There can be ongoing litigation. So due to the current situation, if the company has defaulted some payments, then they would have already filed action. Now a liquidator has been appointed, so it is the duty of the liquidator to bring or defend any action or other legal proceedings in the name and on behalf of the company. So now the board of directors have no powers. They become nominal figures. Now the liquidator has basically to do the job of the board of directors of the company. He doesn't have to continue with the business activities, but he has been appointed for a particular purpose, that is to realize all the assets of the company and settle all the liabilities. So that is his duty, that is his part. But in doing that, he has been granted certain powers. So he should be able to represent the company now. Earlier, the board of directors represented the company. Once the liquidator is appointed, the board of directors have no role to play. The liquidator has to represent the company. Then, to carry on business of the company so far as may be necessary for the beneficial winding up of such company. What is that? Now sometimes these are practical things, but you just have to write the answer. You don't have to explain the meaning of each and everything, but for your understanding, for you to remember these things, sometimes at the time of liquidation, let's say it's a factory. So they would have started the manufacturing process but not completed. They would have started the manufacturing process but not completed. That means they remain as semi-finished goods. Now, once a liquidator is appointed, you cease to trade. You stop all business activities. You stop all manufacturing activities. But if the manufacturing process has not been completed, if they remain as semi-finished goods, it's not beneficial for the company to sell them as semi-finished goods. Then what you can do is, for whatever the goods, if you have already started the manufacturing process, complete it. Convert the semi-finished goods into finished goods and then sell them, because you can you can sell it at a higher price than selling as semi-finished goods, because you can charge more when you sell them as finished goods rather than selling them as semi-finished goods. In that case, to carry on the business of the company so far as may be necessary for the beneficial winding up of the company. Then another power, to appoint an attorney at law to assist him in the performance of his duties. You know, most of the time, the role of a liquidator is performed by a chartered accountant, an audit firm, an accountancy firm. Most of the time, audit firms perform this function as well, the liquidator's function, either lawyer or else an accountancy firm. Most of the time, what I have seen, when the court appoints a liquidator, basically an audit firm will be appointed. That is because they are familiar with the technical aspects of it. However, they may not be familiar with the legal aspects. Therefore, to assist him, he can appoint an attorney at law to pay any classes of creditors in full. So likewise, you have more to make any compromise or arrangement with creditors or persons claiming to be creditors or having or alleging themselves to have any claim, present or future, certain or contingent. So without thinking too much, you can reproduce the whole thing, because this is a power granted to a liquidator. Another one that you can mention is to compromise all calls and liabilities, and you can reproduce this as well. And these also you can mention. The liquidator in a winding up by the court shall have power to sell the movable and immovable property and things in action of the company by public auction or private contract, with power to transfer the whole thereof to any person or company or sell the same in particular. This is one of the main powers, because the main duty of a liquidator is basically to sell all the assets of the company, and from the proceeds that you receive to settle all the liabilities. To do all acts and execute in the name and on behalf of the company all deeds, receipts and other documents, and for that purpose to use when necessary the seal of the company. So section 1, highlight this section because it's a highly examinable area. For the exam it will be important. Section 292 subsection 1 and subsection 2 explains the powers of a liquidator. In your question, they require you to give only 4 powers. So with that you can secure all 6 marks. Only thing, you should be familiar with the relevant section. Okay. So with that we conclude section 2 of this paper. Now we are left with section 1 and 3. So those sections will be discussing separately.